Thank you. This first panel on the alternative resolution of environmental conflicts or disputes is framed within the increasing use of these mechanisms for environmental or socio-environmental disputes. Law 1394 that led to various reforms of the justice system to face the situation after the COVID-19 pandemic and ensure that legal operators should use self-compositive methods for dispute settlement, including reconciliation and mediation, and also align the existence of other methods that are to respect the legal protection. In the case of Santiago, the pandemic was also a relevant opportunity for the use of alternative dispute settlement mechanisms, especially for reconciliation. This organization furthered and guided the process, drafting basis for reconciliation that allow not only the early settlement of disputes, but also reparatory measures effective in order to repair the environmental damage. In this panel, the speakers will discuss legal strategies and participatory strategies in the case of environmental disputes, and also approaches and tools for these disputes, and lastly speak of environmental governance, research, and responsible innovation. And so, first of all, our Professor Carolyn Stamm will speak to us about legal strategies of groups mobilized in socio-environmental disputes in the metropolitan region of Santiago, with contributions on the alternative dispute settlement. Professor Stamm is a Postgraduate Deputy Director, Faculty of Architecture, Design, and Urban Studies of the Pontifical Catholic University of Chile. Fonda Poes has a degree in History, a mention in Geography, Paris 1, in La Sorbonne, and also a degree from the Institute of Political Studies in Paris. She began territorial administration, has a Master in Comparative Studies on Development, School of High Studies in Social Sciences in Paris, and has a PhD in territorial zoning, also from Paris. So, Professor Stamm, the floor is you, and then we will go introducing the next speakers. Thank you very much, and good morning, everyone. As Alamiro just says, I am not an attorney, so I will be speaking from the viewpoint of another field of study, geography and territorial planning or zoning, but especially the legal aspects. So probably I work the other way around as you. I begin with the disputes and follow law, and I do not begin from the viewpoint of law to address the disputes. These are the mobilized groups in the metropolitan region of Santiago, and the idea is to contribute with data on the socio-environmental conflicts in order to think of alternative dispute settlement, which is the theme of this panel. The context of this study is a research that I have just finished in the month of October called Socio-Environmental Disputes in the Post-Analytical City in Santiago de Chile. The research began with increased socio-environmental disputes in the region, and the aim was to lead to what was produced by these disputes. In this area, we studied the legal aspect, the legal resources, as a strategy of these mobilized groups. I would like to say that my research considered disputes as positive element related to social relations, and following Zimmermann, the German sociologist, and also social geography, French-speaking, among others, that sees disputes as moments of governance of the territory. There can be moments of collaboration or conflict, and that this is materializes in the territory. Today, I will analyze the legal strategies of citizen groups mobilized in socio-environmental disputes in the region we are in now. And the idea, as I was saying, was to move ahead with reflection on alternative dispute settlement thinking that there's a need to know more of these disputes. We know little about them and also address the legal strategies for these mobilized citizen groups, believing that these mechanisms that could be of mediation, negotiation, reconciliation, or arbitration are supplementary to traditional resources in the courts of justice. And as I was saying, we know little of the social and environmental disputes. There are several maps of these disputes, most famous and the 8 that I have included down here. However, when we review this in the case of the metropolitan region of Santiago, there are only 8 disputes, 3 active ones, 3 latent ones, and 2 already closed. And if we take other types of studies, for example, the one on the right, very good by colleagues sociologists and politologists, we see that in the metropolitan region of Santiago, there is only one conflict. In this sense, the research intended to supplement or elaborate further on the region that often, if you say in Chile, environmental disputes, that people think of the north and the south, but not the center, and where there is a lot of pressure. And so the idea was to contribute to the urban context and often made it visible in terms of socio-environmental disputes. Yeah, this is a map showing the territory, and I will present 2 methodologies. The first is the one that we drafted to map these disputes. Which are the disputes, where are they located, and we prepared a database with the press cuttings and legal cases. And what did we determine as in the socio-environmental disputes? Public disputes that everyone are covered by the written press and social media. And then we have collective disputes that imply one more or less broad group. What sort of disputes do we have here? To give you examples, here we have 4 disputes that are fairly well known. The first is against the Walmart strike in San Bernardo. The second against the Los Bronces, which has been covered by the rejection of the environmental impact study. The one on the left against waste, and the one on the right, where there are people that are claiming for having a park and not urban developments. So here we have mining, Los Bronces, waste treatment, green areas, and real estate projects. Here we have a map, and we take the 2010 period, which is when the environmental institutionality was modified, and we took the social outpost as the end of the period, and we located 92 disputes, and as you can see, far more than those mentioned in the previous maps. Some disputes, well, there are disputes everywhere. Most districts have at least one dispute, and the most common topics are real estate, sanitation, polluting in industries, mining, and agro-industrial. As we can see here, there are dots everywhere. However, these dots are not all the same. Here, this is not the aim of the presentation, but we did see that disputes in middle to high social classes are projects that are to be carried out ex ante, versus in more popular areas existing disputes contaminating industries, for example. So the distribution of the environmental burden is unequal as we can see in the map. And what I did want to show you now is that we're going to focus on these judicial actions that I imagine is what you're most interested in here. But these judicial strategies or legal resources are located within a much broader repertoire of the groups that have been mobilized. And here we have a fairly well-known list of march statements, citizens' movements, meetings, partnerships, and with public actors or mayors, core deputies, senators, and these are all related to citizen participation. However, these 92 disputes, not all are projects, and so they're not all uh, dealt with in this way. Now, the judicial strategies, and here, how do we work to, aside from these 92 disputes, we went to look if for each one there had been some sort of legal resource by the mobilized citizens. We did not include enterprise claims. We wanted to see how the organized and mobilized citizens resorted to law. And so there, we did a review based on the various means, VLEX, and the judiciary, and we included individual people, neighborhood associations, NGOs, and also public authorities, because in many cases, these are also done in the name of citizens, so we included them as well. And what we found was, of these 92 disputes that we identified, 55% of the disputes considered some sort of judicial action, which is a very high rate of judicialization, very high. What sort of resources used by the citizens? First of all, they go to the Court of Appeal for protection, and we recorded 74 resources for protection. In many cases, there are more than one resource per dispute, as in the case of Puchuncaví. And in some, 40 disputes of the total 92 did have some sort of protection resource. So, as I said, judicialization is high. The second type are the other claims for environmental damage, reclamations, and requests before the second court. 35 judicial actions and went to the environmental court, and the great majority by neighbors. We have the details according to the reclamation, but I'm not going to get into that here. And also, a lot of these resources went to appeals, so we had a very high rate of appeals in these cases. 53 resources got as far as the Supreme Court, representing 38% of these disputes. So the appeals rate, once again, is very high. Also, other judicial actions that I will not get into in detail here, somewhere because the regulation prior to the new environmental law and other more specific types of demands that we could see here in the list. I would also like to mention the low level of success of these judicial actions. Most go to the courts, but what do they gain? They win or lose, or what happens? And in some, there is a very low level of success by these judicial actions, especially in the case of the protection resources in the Court of Appeals. Only 9 of the resources were accepted. As to the claims for environmental damage, reclamations, and requests before the second court, it's higher. So it has once again welcomed these resources filed by mobilized citizens. Of the 35 cases, 9 are under study, 13 were accepted, and 13 were rejected. And then finally, what happened with the resources in the Supreme Court? Here, the balance is fairly even. 28 of the resources were rejected and 18 were accepted, and 2 they desisted. But Although citizens do frequently go to the courts are not necessarily where their claims are resolved or where they win or lose in relation to what they're asking for.
Now, we did a more qualitative work, and we asked the activists, if we can call them that way, why did you access the courts? Why did you go to the courts? I mean, if you win so little, what are the benefits you see in those legal strategies? So I will present some results of interviews that we conducted in the metropolitan area of Santiago. And then I would like to say that the adversarial system of courts, as compared to dispute settlement mechanisms, is something that citizens value when they access the judiciary. So there is trust or confidence, and there is a need to win or lose, more to win, that is. And so I've quoted there. The experience says that the best results are obtained in the courts of justice. Supreme Court is viewed as a more favorable court. Other inhabitants say, no, I don't like the demonstrations. That's why we prefer to organize with legal support to reach some point. I mean, protests did serve for something, but the legal path was better. And finally, the ESEMA director rejected our complaint, so we needed to go to the environmental court to habeas corpus. And today, this real estate company is in a process of sanctions. These are groups that won in some court, and they trust and value the right to access this adversarial type of justice. But in many cases, citizens lose, but likewise, they do value the recourse to justice, and it's not more than winning or losing, but it's something that Natalia Labé mentioned in her thesis. And I thank Natalia that she's a lawyer and she participated in the project and reviewed all the legal recourses. And she showed in the work on Tiltil that finally citizens access the court first to paralyze the project. That's one of the actions obtained, and to evidence or make visible this dispute in the public. So there are some interviews saying that in legal juridical terms, it's a permanent dispute and fight. Partial victories have been obtained, but everything is in the dispute. In objective terms, yes, a lot has been achieved. There they value that although legal recourses take time, and there's not only a victory for these movements, at least the issue is made visible, the perspective is changed within the public mind. However, there are limitations to these legal strategies that are well known, that have to do with the cost and the time involved in habeas corpus or legal recourses. And here I gave you two quotes of environmental players say, go to the environmental courts. There you can get justice. And there we can start investigating and see how can we fare out. That is 2 million pesos per lawyer. And others say there is a deficit of legal knowledge. So this access to justice explains why many of those movements resort to habeas corpus, because that is the cost is lower. Final comments or final decisions. Here in this study of judicialization of disputes by inhabitants and mobilized collectives allow us to understand access to justice and use, and highlight the judicialization of environmental conflicts in Santiago. The legal strategy analyzed the success of legal strategies. There is a low success. but it is an essential strategy articulated with others. The legal strategy is not isolated because while you go to court, still you have demonstrations in the streets, in the media, working with authorities, with senators, representatives, political pressure. There are different actions that are parallel to this legal strategy. And also, I wanted to underscore the interest for these demonstrator in the adversarial system, where there is a deficit of assistance and participation in the environmental assessment instances where participation is at a late stage without space for debate among the different actors in the dispute. And also there is a deficit of policies where many of these decisions are not the result of political decisions by mayors or regional governors. And therefore, in this context, citizens seek a response, an answer that is a winner or a loser, that is viewed as an alternative solution to the lack of room for negotiation in the different territories. As to reflection, in order to think about solution dispute settlement issues, I'd like to refer to 3 points, 2 references of colleagues from the Catholic University that worked about proposals of mechanisms to have a council of environmental dispute settlement, and second, a community panel. That is the other proposal. And as to these 2 proposals, I mentioned 3 relevant points. One, the object of the dispute, the scale. We are thinking about mechanisms for what type of disputes, at what sectors, and what type of scale can you think in alternative dispute systems. Secondly, the time of the dispute or conflict. Many proposals raise mechanisms for initial stages of the project before being submitted to the environmental impact assessment. And others, there are other alternatives like territorial dialogues, but many of these conflicts I presented are facing agencies that already exist. And last is to think that maps of actors are dynamic, they change, they move, and there are power asymmetries among the different players of this or parties of this dispute, depending somewhat on the object of the dispute. But these asymmetries need to be thought out within the framework of this alternative dispute solutions. Thank you. Well, now we'll give the floor to Professor Luis Lemkow Zeppelin. He is professor, an emeritus professor of the Institute of Science, Environmental Science. He's a doctor honoris causa in sociology and geography. He is an expert in environmental and technological risks, environmental justice, and the relationship between environment, health, and social inequalities. Remember, you can raise your questions. There will be 20 minutes at the end of this session for that purpose, for Q&A. And so, please, you can submit them in writing so that they will be addressed to each speaker. So now I give the floor to Professor Luis Lemkow for your presentation. Thank you. Good morning, bom dia. Greetings from Catalonia. It is a pleasure to participate. It's an honor to participate in this international forum of judges for the environment. We have prepared a presentation that is quite generic, but there is a complement. There is a supplement that is a concrete case of a dispute in central Catalonia about the display of renewable energies. I won't have time to to go into details of the case. There's no time for that. But what we can do is distribute the paper, and so that you can read it and see things of this concrete example. And I speak in plural. It's not the true plural, but I say that this presentation has been prepared by two people, myself and Gonzalo Gamboa. He's a researcher of the Institute of Environmental Science and Technology of the Autonomous University of Barcelona. He is a Chilean researcher, and he was unable to attend here, to come here, but he's an expert on multi-criteria assessment. This is one of the things I wanted to present here. I will distribute a paper that he has prepared. It is a case of Aysén in Aysén, Chile, and so it could be of interest, and trying to develop this technique of social multi-criteria evaluation. I have 7 key words in order to guide my presentation: socio-environmental crisis, inequity, risk proliferation, perception, distrust, Catalonia. I will not speak about the political process there, but about other environmental issues. And then finally, multi-criteria assessment. So, socio-environmental crisis. We have used for this forum, for this environmental forum, but also you have adopted the socio-environmental word, precisely because environmental themes cannot be addressed with mere technical, ecological, environmental dynamics, but rather the environment has been shaped by human beings. And the environment impacts on us. And this is important to point out: interaction between environment and society. And that is why we have used, and for many years I've used the word socio-environmental, so as to incorporate these two spheres. There's nothing separate. They're part of one same whole. I also use the word inequity, and obviously this is relevant here if we are speaking about environmental justice, because in socio-environmental subjects there are many inequities, and one of the key elements is that the majority of environmental impacts have an effect on the most vulnerable communities with less environmental resources, and therefore you have the issue of fairness or unfairness. And this fairness or an unfairness is a structural component of what we call socio-environmental disputes or conflicts. And of course, they are inevitable, these conflicts. Sometimes it is understood as something negative, but disputes or conflicts can generate important positive changes. It's not a classical view of conflicts, but it is inevitable and is on the rise precisely due to the proliferation, that's another word that I've used, proliferation of environmental risks. That is, there is a tremendous variety, a whole range of environmental risks. We are very much focused today on climate change, but there is a plurality of problems that we face in socio-environmental terms, and this is important. And if there is proliferation of risks, then we can perfectly understand and expect an increase of disputes. And this is precisely what has happened in Catalonia. We have different socio-environmental conflicts, and I will refer to that later.
And also, the proliferation of risk has an impact on public perception. That is, there are many determinants of public perception, and I will not get into that because this could take a number of hours, but merely say that the proliferation of risk does have something to do with public perception of our surroundings and also the translation of this into action and political activism when it is something that is really important. But if we're speaking of proliferation and characteristics of the socio-environmental crises, first of all, focusing on climate change, um, it's at a planetary scale, as we know, but the impacts are global, and so it's very important to insist on the local aspect. Also, one very important issue that we are very subject to is certification by the media, but in fact, climate change and many environmental issues are of difficult detection, measurement, and control. So these are not visible, tangible things. Climate change cannot be touched or seen. The industrial mists, you cannot see it. And so this affects our perceptions. It is insidious. It's something we cannot see, you cannot touch. And then the outcome is uncertain. And having said that, if we want figures, we have COP27 ongoing, and even scientists at community level, they do not agree either. So there is tremendous uncertainty. Something that also affects our perception of the social environmental crisis. One thing that I have said is that in this case, climate change has an impact on the most vulnerable communities. And this, well, we have a lot of data on this. I will not get into an explanation here. But this is nothing new. Historically, the environmental declaration has had an impact on the most vulnerable groups. And the socio-environmental crisis goes far beyond climate change as such. And personally, this is of concern to me because we need socio-environmental policies. We're focused on this. Yes, of course, we're focused on climate change. Yes. But also, we have the loss of biodiversity, and that could even be of greater impact than climate change. It is also related to climate change. And severe pollution, yes, we continue with this since the Industrial Revolution and the depletion of natural resources, and speaking here in Chile, aggressive extraction of natural resources. And this is a very relevant topic. The extractive activities do have an impact, and a lot, not only locally, but globally. And so all of these elements have an impact on perception. And I'm hoping to receive comments on this. So This situation has led to a feeling amongst society of uncertainty, insecurity, and a certain disorientation. And it has also led to a word that we often use, and that is mistrust of institutions and administrations, because in many cases they have not addressed social environmental disputes before, and in the face of a truly relevant crisis, there is great mistrust with regard to the capacity of these institutions to uh, affect and regulate. And also, when we're speaking of perception, we must bear in mind that often people who protest, who are immersed in an environmental conflict or socio-environmental dispute, they're not speaking merely of health or the environment. In many cases, the dynamics and the conflict have to do with traditional activities that are being questioned, and also lifestyles, daily practices that also are also being questioned in the view of the deployment of renewables, for example. And also mistrust, and I think that this is a very important aspect, also mistrust on account of the biographies of um, the administration and the public. The use of the term, which is despective, not in my backyard, I don't want this, and Lulu, locally unwanted land use, and these concepts dismiss, radically speaking, the different players, and does not help. It does not create an atmosphere of trust among countries that, especially when they want to deploy renewable energies or technologies. And I think that this is the sort of framework that we move about within. And so now I would like to move on to the case of Catalonia. Catalonia, as in many other territories, there's naturally a number of socio-environmental disputes. And the interesting thing about this, I don't know if the word interesting is the most appropriate, but there is this occurs with the deployment of renewables technologies, uh, renewable energies, renewable energy technologies. And the curious thing in this sense is that there is consensus in favor. We're all in favor. But when it comes to deploy the technologies, we get into disputes. And so, in the case of Catalonia, there are 60% of these wind parks that occupy 15% of the territory. So, highly concentrated. And historically, it's not only with the renewable technologies, but also other environmental liabilities like toxic waste, which are usually sent to the poorer sectors of the territory. This is nothing new, and that is exactly what is happening in the case of the renewables. And so people ask for democratization of these locations and also transparency. That is why the request is that it be decentralized. So this is the framework within which we must move. Now, Generalitat of Catalonia, the government, is aware, as are many others, public organizations of this situation. But the government, the other day, I had a meeting with the number 2 of the Ministry on Climate Change, and she was absolutely flabbergasted with the situation. But yes, they do understand it. This resistance comes from far away, with the interaction, the administrative interaction of many public organizations. And this has led to a culture of rejection, mistrust. Once again, I repeat the term mistrust. And then, speaking of the concrete situation in Catalonia, there is a magnificent paper called Alcaraz. I don't know if any of you have seen it already, but precisely it describes well, the objective of the film is not a critique, but it does explain the impact of this deployment of these solar boards, solar panels on a family of farmers, and which clashes with their traditions, their lifestyle, and their future very directly. It leads to a lot of tension internally. This is a film that is presented for the Oscars in Spain. And so it is a Spain that is it is a film that is well worthwhile. But it locates it very well. I'm running out of time as usual here. We published a book about 10 years back, a collective book on a white paper. And one of the major themes, it's almost 7 years since then, was the renewables. And despite social consensus that we do have in favor of these technologies, there have been also many concerns on account of socio-environmental issues. Mediation, obviously, is an instrument that we can use and that we are already using. And one of the problems that we have is an accumulation of concrete cases going through the courts of justice. And there is a movement to try and bring forward the settlement of these disputes. But I like to say that it's not just in the courts of justice. They're not necessarily the best instruments with which to settle these disputes, these social environmental disputes. I also wanted to say that in general, municipalities in Catalonia are aware of the difficulties and above all the need to decide in favor of participatory strategies, and there is a lot of activity in that area right now. And what I was going to say, that there is a technique among these participatory strategies, which is multi-criteria assessment. I have no time left, but in any case, you do have the paper drafted by Gonzalo and the one that we have prepared for the forum. And this later on, well, we can be distributed. Thank you.
Thank you, Professor. Thirdly, we will hear Gonzalo Frei Toledo. He's sociologist, mediator, and facilitator, licensee in sociology of the Catholic University of Chile, master's degree in analysis and dispute settlement of George Mason University, and he's a teacher in negotiation, mediation, and dispute facilitation. He's director of the mediation degree of the School of Law of the Alberto Hurtado University. Please, Gonzalo, you have the floor. Thank you very much. Good morning. Thank you for the invitation. And Judge Del Piano, through you to Santiago, to all the courts of Santiago. I will speak from my experience in academia has to do with teaching and also from practice as mediator, facilitator, and my interest is to speak about all specific tools applied to environmental disputes. And I'm not a lawyer, so we have somewhat the margin to say things. Sorry to the lawyers, sometimes we may say things that are not very much correct, but some initial concepts. Dispute or conflict is not something negative, but rather is something coexisting in society. Jean-Paul Lederach, who is a worker and activist in different spaces of disputes. Conflicts are not necessarily managed and solved. They are transformed. It is a transformation of conflicts more than a concept of resolution, and understand conflicts as not as something negative, but rather as something positive that allow to install processes of change in any society. And therefore the challenge is how to use those constructive forces in a conflict to create something new, avoiding the destructive potential. Recognize that behind every confrontation there is a need to work at different stages, different times, not only during the crisis, but in the more structural and systemic moments that are present in every conflict. So the first leap I take is more than the resolution of conflicts, it's rather the transformation of disputes or conflicts. And although the invitation to this panel is to speak about alternative dispute settlement in the last 20 years in academia and world of practice, has spoken about adequate concepts. It is adequate or appropriate in more and collaborative. That's the concept. How do we work in collaborative processes? As an alternative means for dispute settlement or dispute resolution that refers to an approach that sees all these procedures like reconciliation, mediation, negotiation as alternative processes. And therefore spaces like mediation, reconciliation, and facilitation would be alternative paths, alternative to the main path. And it has sometimes been viewed as a second category justice or anomalous resolution. But opposite to that, literature and practice has thought about these spaces not as alternative, but rather as collaborative. And that is the word I will use. Understanding them as different spaces to adjudication. And think more than in an alternative approach, rather see what are the most appropriate mechanisms to work on the conflict. That is the question we should address when we speak about appropriate mechanisms, because the alternative fact was promoted in the 90s in Latin America as dejudicializing something, how to bring it out of judiciary, and generated aspects like family or space or social discussions. And in some way, as a counterpart, the pluralism of processes, as Mrs. Miller speaks, promoting different mechanisms allowing to obtain different results. This new approach forces you to find the most adequate mechanism depending on the use and results. Taking these two aspects, the collaborative and resolution of conflicts, I would like to work on this idea of the collaborative governance, understanding governance, bringing together, taking the definition of Geringer and Kitsaber, that brings together all the actors in a space, public agencies, citizens, communities with interest in a specific subject, coming together to speak about what needs to be done, what should be done. This is a space of governance, collaborative governance. And from this perspective, we understand collaborative processes in the context of socio-environmental conflicts, a space where first a series of subjects related to a place or territory where an intervention is made, there is pollution or there is conversation about a policy or a plan. Secondly, where more than one sector or player is involved within, or stakeholders rather, where there are different agencies, governments, private enterprise, or multiple levels of stakeholders, citizens, activists defending environmental rights, local leaders, regional, and even international players. And thirdly is to involve the parties and have them work together to provide recommendations, adopt measures, or decisions that will affect the interest based on a majority consensus of participants. And the question is why the collaborative approach is relevant to face the socio-environmental global challenges. Well, first, the promise of collaboration has to do with facing challenges in climate change. There is a global challenge. Climate change requires joint actions of multiple institutional and social players to work jointly to address them, the challenges, the complexity and uncertainty of the present situation in the world. Jointly with that, and taking the subject of distrust, you need the building of relations among the different actors to have shared scenarios about the social, economic, and environmental goals of different territories, leaving the adjudication or the loser or winner scenario. And also it means collaboration means involving early on those citizens or the citizens in collective decisions that will affect them and have a genuine interchange of communications and reaching joint solutions. Conduct collaborative processes, of course, has limitations and cannot be considered as spaces replacing the judicial path. They do not substitute or replace the judicial process. I'll give you an example. In Chiloé Island, some years back, there was a problem regarding the disposal of house or residential waste. There was here the idea was to have these lands that already have completed or wastage, and they affected the marshlands of Isla Chica, and these waste dumps have completed, have reached a deadline that is of life cycle, and therefore you need to replace this landfills, and where there are many players, and they do not want to have them closed because there is a natural reserve here in this area of Chiloé. And in this context, the access to the judicial process has enabled neighbors to access justice so as not to have these dumps, waste dumps close to their homes, but allow the players to come together and think about a solution about how you could achieve the disposal of this. What is the reach? What is the scope? That's wonderful for the implementation of this. But the lack of dialogue or decision-making to face these complex problems raises the issue if justice can facilitate spaces for a different conversation, a different kind of conversation. So there is where I go into mediation and facilitation, two specific tools based that it really can contribute to the discussion. And both mechanisms already exist in some legislations. In Chile, you have regulation as to mediation in other areas, in family, labor, but not in environment. In adolescent criminal justice also, but in environmental area, it has been discussed. There was initiated in a partnership of miners where they started to discuss the possibility of early dialogue and mediation as specific mechanism. Jointly with the Catholic University, that conversation has been present, but no progress has been made. Why do I take these mechanisms? These are processes that can be thought in a supplementary and interchangeable manner. Both the figure of the mediator and facilitator, both are professionals or professional teams to promote encounters, collective processes of voluntary exchange, and can reach and allow different parties to adopt decisions with different stakes. And to take one definition here, the North American Agency of EPA, Environmental Protection of the Agency, defines facilitation as a process used to help a group of people to have constructive discussions on complex or potentially controversial subjects. The mediation is defined as a process in that they have different stakeholders, different consultative players. Mediation is a process in which a neutral third party, the mediator, helps the parties in the dispute to reach an arrangement or a settlement of their differences. Through innovative solutions allows for cooperation and shared results. And the EPA uses in a different of matters, administrative permits, and many other things. As to when these mechanisms can be thought, no audio, I'm sorry. It's off. The microphone is off. No, I'm sorry. No audio.
Ahora sí, ya. Vale.
Now, yes, it seems that it is working.
Vale, gracias. Pero no está lateando, apagar el micrófono. Entonces, bueno, tanto la mediación como la facilitación
So
requieren
mediation as well as facilitation require of multidisciplinary professional teams with the ability to generate collective bargaining and decisions to be made. The focus of facilitation is the ability to commit people to work together collaboratively in disputes, but with knowledge of group methodologies and that may accompany a constructive dialogue in order to reach an agreement, and working early on generating a dialogue on environmental matters. Mediation is a more structured and is used to address specific disputes, but these could be used not only as tools at the start, also during or if the dispute has peaked. It can be used, of course, in different moments of the dispute and facilitating education processes, meetings, but you want is for this to be at an early stage and not once situations have reached an unbearable situation. And so people tend, if the dispute has evolved, tend to prefer a more legal and process. But especially when there are controversies, and these are mechanisms used in the different stages of a project. And to what extent are these processes important instruments for environmental justice, and why should they be addressed by the institutionality? Well, we have talked a lot about this. Environmental disputes in the region occur with high levels of mistrust towards the institutionality, which is a world phenomenon, but in our region, and particularly in Chile, we have not only high levels of mistrust of the institutions, but also of the people, which means that the challenge is even greater. And so these collaborative processes allow coming closer and allow a better relationship among people. It is key to work with the symmetry among the parties involved, which is necessary for these processes to be promoted and safeguarded by the institutionality in order to ensure key elements such as the symmetry of power among the parties, ensuring that the process be not affected by the interests of corporate players, but that it be done based on equality, equity, and quality standards. At present, many enterprises have a community outreach activities, and this is all very legitimate. This leads to negotiation processes, but it is direct community enterprise. Here we're talking of how the institutionality safeguards mediation and facilitation processes at a public level, and so ensuring that there are symmetrical processes, informed access, and ensured participation, and not that the processes are opted by one of the parties. And so somehow the question arises, should these processes be part of the judicial or administrative authorities? Well, it is an open discussion. There are some connected to the courts as well as other processes carried out by the executive. since the socio-environmental aim is mainly linked to initiatives that are also of the administration, there's a risk that the loss of independence of the teams responsible for facilitating or mediating these processes among the stakeholder parties. And so environmental mediation, in particular connected to courts, could be affected by red tape, and losing the inherent flexibility of these processes have such a through facilitation and mediation, and are affected by formal practices of the process. And in that sense, one recommendation that we as a team made within the context of this study that I was telling you about earlier is that maybe these mechanisms, mediation in particular, could be integrated partially to environmental courts, and if there be protection of by the courts of the mechanism. And so the judiciary may act as an instance for control for the legality of the agreements if they are reached. And for example, family mediation in the case of Chile, there could be an agent to refer the processes and also ensure the quality standards of the professionals involved, ensuring quality. And this is very relevant because we should not confuse mediation with other spheres, such as very legitimate experiences at family level or civil level. Environmental processes requires the professional teams that have the skills to deal with these processes. It is necessary to have professional teams and multidisciplinary training. Well, so mediation and facilitation are inscribed as key processes in order to create generation and trust and access to the information by the interested parties. They do not substitute the fundamental role of the process, and there are other aims that have to do with the need for environmental justice and also recognized under the Escazú Agreement. As the person from the Supreme Court said, it's very important to promote this sort of mechanism so that it may methodically lead to conversations regarding the dispute at the different moments of the project. And so we can lead to a peaceful dispute settlement through collaboration. But the legitimacy means that you need institutional backing and to ensure the legality of the agreements and that they can be reached in this space. Thank you. Before introducing our last speaker, we would like to recall that for your questions, you must write them out, send in, and they say who you're addressing the question to. We will be seeing them at the end. So now we would like to introduce Mr. Johannes Rehner, who will be speaking to us about environmental governance and research, and he is the professor and director of the Institute of Geography of the Pontifical University, Catholic University of Chile. He's also studied in Germany, Munich, and his main areas of research are economic geography, Asian studies, and sustainable urban development. He's also a researcher in various areas. Thank you. And I thank you for inviting me to be here. I understand that this is the last presentation by us, the alternatives, who come from areas somewhat far removed from law as such. What I would like to discuss now is to take a step back in comparison to the presentation by Mr. Frei that we just heard, recovering the concept that he introduced at the start, which is governance, and emphasizing above all on power and related to governance processes and the various agents involved, and also linking that to innovation and responsible research. And why this last point? Well, basically, because knowledge plays a key role, especially in alternative processes for dispute settlement, and to a certain degree, an attempt to place on the table the relevance of a certain recovery of rationality, seeking legitimization of certain interventions through rationality. So, the first thing I would like to present, well, clearly governance is a concept that implies a challenge for the conceptual theoretical work. A concept that here appears with certain differences from the definition that we just heard in the presentation by Mr. Frei. However, I would like to highlight here is that we're talking here about created interest regarding distributed resources, and this leads to what Carolina mentioned as a certain unavoidability or inevitability of these disputes. But what appears with this definition is the search for common goals and the legitimization of these common goals, that they be accepted, at least to a certain degree, by the various stakeholders that are involved in the dispute. Does it mean that there are equal interests? No, and far less equal powers. But the idea is to find common goals, elements in common. And quite clearly, this occurs in a given space. It is not necessarily anchored to certain places, nor does it have a direct relation to a space, because it's also resources are spread out in space, and interests are also anchored to a certain place. And based on the approach to the place, that is how the negotiation processes among the stakeholders occurs. I would like to introduce an example and take you out of the context where we are here. A conflict that we have done a study about 20 years back, that we did a study on the implementation of the World Football Cup in 2006 in Germany, in the state of Munich. What we're seeing here is the Olympic Stadium that it is in a city that has a certain environmental relevance. That is the city of Munich, and within the context of the World Cup, there was this need to have a modern stadium and with a shopping center and others. And of course, this did lead to a conflict in terms of what would be desirable as a city. It led to a conflict regarding the concept of the city. But then there was a mobilization by citizens regarding the validation of the green space as something that is important to the city and that makes up a city and that adds relevance to the space in that sense. So the first thing is that the various players involved ultimately decide where the financial resources go and build the stadium based on their needs. However, the relevance of this space, the symbolic relevance of the space in the city, such as the green recreational space, obliged the main agents to rebuild the Olympic Stadium, because this meant keeping the roofs that are a World Heritage and the glass, keeping green space, and basically get rid of this existing stadium and build a new one in a sort of dig-out area that is produced. However, this shows how different actors are involved. And this was greatly criticized by the Chamber of Architects, and was finally, the plan was withdrawn by the architect Venus. who was responsible for the reconstruction. And this is the interesting thing. He had the copyright of the entire complex. So this is a classic mobilization of a copyright resource, and that prevented legally any type of intervention. So as a result of this, there were various alternatives that arose with regard to the stadium. One, a readaptation of the space was no longer possible.
And there were a series of definitions based on mobilizing power resources very different among themselves. First, based on an environmental assessment or evaluation. This point had the financing and support of the political sector because it was a mainly private financing. So it would have meant for the state to save a lot of money. But then it was really erased from the map due to the environmental impacts of the traffic that would take place. There were two places also in the same Olympic Park, and they were taken out of the list of alternatives because of citizen demonstration protests, and it became ever more powerful in spite of having been initiated by neighbors living there, but it became powerful because it threatened to file a complaint against the district. Possibly they would have lost the trial, but if it had taken place, they wouldn't have been or had time to build this stadium. So what Professor Steinberg had said, the fact of delaying or paralyzing, here it was merely a delay, but that is what made powerful this power recourse of citizens, regardless of the final decision. And finally, the same municipality of Barrow used its power as an authority. And finally, as there was so much public discourse, all that process lasted 7 years. All those public debates about the different places or sites for it. And that made visible on how necessary it was to get legitimacy of the project in public opinion. And to have the public legitimacy, well, finally, you had to submit that to a referendum. It was the fifth alternative was approved in the referendum, and it was there that the stadium was built. Without that referendum, it couldn't have been built. And the referendum had tremendous support because when there is a referendum for a mining project, usually that is not the case in Chile, but in other Latin American countries, yes. And there's broad rejection, ample rejection. So in those 7 years, there were many public discourses about the need and importance of this project. So what we can see here is a process, a debate and a permanent debate and public negotiation. Yes, you can reach a consensus that is expressed in the referendum. And what's even more important, different rejections of different alternatives showed how certain agents with very little power resources can become extremely powerful at key moments of the biography of a conflict or dispute. What was finally built was this stadium, and I wanted to add this quote. For us, those that understand consensus as a disputed reality. In a good day, everything seems full of hope, as an expression of that possibility of reaching consensus. So, what we were discussing now has to do with the different power resources For example, financial resources, authority resources, they are mobilized by different agents in these conflicts, and how that is finally expressed in the territory. The territory thus being a space of power, of domain, and it's never defined in a fixed manner, but rather it is a relational concept that is expressed in the moment when exercised. Before that, it's simply the option to exercise power. And so, taking that to the Chilean context, it really strikes me the fact that I'm in the Chilean context with statements about the absence of culture of dialogue, the absence of the idea of negotiating without assigning a negative negative meaning. I mean, but it's also linked to the tradition of the idea that there are specific groups where they do lack power, where it's very difficult, although you can mobilize certain resources, but it's much more difficult than in other contexts. And that can be interpreted from a phenomenological approach of the concept of justice. The need to recognize, acknowledge your counterpart, the other party, and recognize the voice of the other party. And that is a certain tension that is produced with the idea I mentioned about rationality. And in environmental conflicts, we would need to accept that the voice can be legitimate, although it has a different rationale from a different rationale from science. As to space and environmental conflict or dispute, we can see here a series of classical approaches. In my discipline, where on the one hand you see how on space you have certain vulnerability criteria with the presence of conflict, all that coinciding, leading to the idea of environmental injustice, or the location of sacrifice areas. And here, linking this rationale of area of sacrifice with the idea or legitimacy of neo-extractivism or extractivism based on the growth and development needs. However, from the point of a more critical standpoint, colleagues from the University of Chile, for example, Bustos mentioned that they are working from a perspective that is political ecology, emphasizing the idea of the commoditization of natural resources and the subject of metabolism and environmental intervention role playing or played in the metabolism of space. New trends are added to this debate. For example, the emphasis in ethno-environmental conflicts, where we are currently speaking about a phase of discussion that could be labeled as post-multiculturalism. But in the mentioned cases, what becomes more visible and is somewhat parallel to the example I gave you before, here there is a mobilization of power resources that's quite novel, based on certain legal changes with the 169 agreement or convention, with a greater voice in public debates, an issue of confrontation of different stakeholders that do not have to do with the related ethnical groups, but, for example, conflict between mining and tourism, that also offers the possibility to other groups that traditionally had little resources of power to become more visible, and now they become more visible, or certain technological changes like, for example, the social media. I will move ahead. I don't want to skip, but rather mention the gender approach, the gender view in these discussions, especially linked to those sacrificial areas. In processes of conflict, one as important as that of the ISA crisis is the salmon growing area in the south, where different knowledge systems play key roles in searching a solution to conflicts, not necessarily juridical, but not only the possibility of avoiding them, but rather building a new institutionality where, with the spatial consequences, where to be located, where to monitor. In the end, there is a tremendous need of being fed by the construction of scientific knowledge, allowing for the management of conflict before reaching a judicial resolution, legal resolution. And there, where you have the idea of responsible innovation and research, a concept promoted by the EU recently, emphasizing the idea that through transparent interactive processes, the different social players and those agents that promote and drive innovation are in a process to be responding each other, to respond to each other, with the idea of achieving ethical acceptance based on the concept of sustainability, and also evaluating the need of innovation and of products promised by innovation. Four key criteria I would like to mention: anticipating a research or investigation, anticipating the possible impact, something that really failed in the ISA crisis. Reflection, that involves the reflection, the thinking by the researcher about his own action. And that involves the role of this researcher that is investigating. In the end, what is his or her contribution to knowledge in order to respond or solve social or environmental problems. The inclusion of different agents. We saw the example of Germany, where different agents start to intervene in the process, and very rapidly they assume roles like the Chamber of Architects or the IPR, or the agency assessing the environmental impact, societies, and then finally the response capacity of different processes. That's a key element because it refers to the capacity of processes to create knowledge that will respond to the need of that specific place at stake, the space where that territoriality is exercised. It was rather complex. I will skip a couple of slides and get to the final thought, final reflection, to say that from my perspective, the settlement of environmental disputes should be understood as a process and not an instrument. It should be understood as a process of governance. Governance, what I said at the beginning, with interest at stake and in conflict, but do have the possibility of negotiating and finding a common legitimacy, a common ground. And there we need to say that conflicts have a biography, different agents intervening. Partnerships change throughout the biography of a conflict. The discourses of legitimacy and legitimation change. It's impossible. It's important to identify the ethical legitimacy, the different interpretations that provide grounds to find a solution that is feasible, acceptable for different participants. In all of that, consider the geographic scale, the local arrangement or local situation, and of the ethical judgment, and finally recognize the exercise of power in space through territoriality. Thank you very much.
Inicio la ronda de preguntas.
Thank you. And now we're going to begin the Q&A period. So please send your questions in. We're going to, on account of the time, limit the questions to 2 per speaker. First of all, for Carolyn Stamm, the first question reads, do you identify a public policy plan or program that seeks to further the solution of environmental disputes? 1-to-1, I think, would be the best way to go about them. Well, I think that maybe Gonzalo answered the question. In Chile, there is no regulation in environmental matters for dispute settlement. However, there are experiences, many there led to negotiation before the presentation of mining projects. And so for miners, there is a PPP aspect to this, public-private, or the pilot at territorial level. So in my view, there are some pilots, but there is no public policy that may be widespread for environmental matters and that may now be favoring these dispute settlement mechanisms. Professor, second question for you. It says, of all the judicialized disputes that are part of your study, it is possible to identify if these were projects or activities that have gone through the environmental impact assessment study, or are they foreign to the process? Of the 92 disputes, half did go through environmental impact study, and so it is a very high number, and also most conflicts identified in relation to a real estate issue has to do with disputes that have passed the environmental impact study. So if it has gone through the system, yes, half of them, yes, but the other half not, because these are existing projects, plans that are already in operation or others that are not yet in the system. So the answer is yes and no. Now for Professor Lemkow, first question reads, how to determine the priority of environmental disputes linked to vulnerable groups such as the indigenous people? How to determine the priority of social environmental disputes where there are vulnerable communities involved? Well, the thing is, I do not know how to answer it.
Vamos a poner una segunda pregunta, profesor. Dice,
well, let's go with the second question. Professor, in your view, how would participatory strategies contribute a better tool or alternative to settlement in comparison to what is done by the environmental courts? Well, I believe that we have many examples of successes, and precisely what I was going to present, but I did not have the sufficient time, that in central Catalonia it was possible through a multi-criteria assessment and obviously with participation by local people. And so, yes, so the question is that it is possible to say that it depends. It depends a lot. It depends on the conflict of the dispute. Some of these, well, I would say that a court is not the most appropriate instrument to use. And often, through these participatory mechanisms, we can get the different stakeholders and actors to come closer and hopefully reach a consensus among themselves. Sometimes these positions are totally legitimate, but that there is a certain confrontation. and putting together a dialogue often or sometimes, I cannot say it is always, yes, but it is possible to reach a consensus, and this is the way out of the difficulty. And so then afterwards, the institutions are able to respond. And so obviously, what we are is involved in this, and we defend it as an instrument that is useful for as a way of overcoming disputes and issues. Local knowledge is important. So we're thinking of hydro generators. Sometimes the local community knows far more than the technical guys who have made the proposal for a particular location. So it is possible to reach interesting outcomes. Well, thank you very much. And now, but in any case, let me say that one thing I have not said much about it during my presentation, but I do believe that we have a real drama in Catalonia, not only on account of the conflict, but also because we're at the tail end in the deployment of renewables in terms of autonomous communities and the state. And I believe that this is a matter of great concern for us in Catalonia. Thank you. Well, now for Gonzalo Frei, I asked you a question. What should an interlocutor do to be validated by the parties in the different stages of environmental disputes? Well, that is a good question. The facilitator or a mediator, or the process to be valid, must be legitimate by all parties involved. And for that, it is insufficient to merely declare my impartiality or coming from a particular institution. No, based on my experience, what is most important is that the people who are taking part, the activist world, the communities and so on, they should perceive that the facilitator, the mediator, is in fact someone there to support the process. As Johannes was saying, create the governance, create a space of governance among the stakeholders so that, well, especially those that are usually most invisible, should not see the space as a space for merely a transaction. But this is the space that they could take their voice and raise their demand. These are not instances that shut others up. On the contrary, they open up and are ready to listen. And the idea is to meet their needs and interests, and that there's support behind a legitimate process. And that has to do with the trust that people place in the process. And then a second question for Gonzalo Frei. In what you call the transformation of socio-environmental disputes, do you believe that priority should be given to collaborative pathways, formal or informal, and first, and then the adversarial ones? No, I don't think so. I think that I would say that the adversarial, I would say that this is not a core issue of collaborative mediation or resolution. What I do believe is that systems should consider a diversity of processes, that there's an ability to read the conflict. For example, in that sense, in many courts, it's interesting what they say regarding the early assessment of the cases, or are referred here, cases that are mentioned here as not being admissible. Maybe legally there's no point in making them visible. Maybe these are more appropriate because there are issues, because that maybe leaves a social tissue broken somehow. But maybe they do not have the legal visibility for that. But it is possible to assess the possibility of having these mechanisms because there is a rupture in a community at a territorial level. And how can the institutionality address this? Maybe from the judicial viewpoint, it is not admissible, but maybe the work can be done at territorial level because otherwise the the dispute continues to fester, so to speak, and people do not make their claims visible if the institutionality is not giving a response. And now, Johannes Rehner, the question is, according to what you have said, citizen participation in early stages and with the ability to decide legitimizes projects. How is it possible to ensure that each initiative has a participation process involved? And second, how do you believe that the project developers could, that their reactions could discourage investment? Well, you've understood correctly. It is very important for citizens to take an active part in these processes right at the start. That is why these conflicts or disputes evolve. It is very important to have early inclusion for them not to fester. Now, the legitimacy don't necessarily need legitimacy for all parties. This is part of the governance process, that the legitimacy logic of each of the participants could be different. And so it is important that the process in itself, or the project that we are speaking of, may find a ground in a legitimacy that is agreed on among the participants. And this may sound not very practical, but I mention it because this could mean that some projects come apart because of this. Yes, that could happen. But I do believe that it is also important to consider the context of a certain sphere. And I personally believe that the problem in Santiago is not necessarily that it could be that a project dissolves. And I would not see this as something so dramatic that might discourage investment in projects. Thank you. Now, a second question. Do you believe that the absence of the cultural dialogue in Chile addresses the need of groups whose shortcomings could affect environmental waste as has been seen in Germany? Well, of course, yes, the vision. There are groups that lack resources, have no power. This is based on facts, and also historically, we've seen this and how traditionally decisions are made. These are slow processes. Germany is a decentralized country, and so you have this logic with referendums, and there are certain groups that meet at almost a local level and that they decide on the projects. That is how it's done. Very well, Professor. We have an additional 5 minutes, so we're going to take a few more questions. Luis? Yes, I wanted to add to the situation in Catalonia. The establishment of wind power parks is seen as extractivism because the benefits are transferred and there is an impact on social life. And so this is seen, like in mining, as extractivism from a particular place without bringing any benefits to the local community. And this has appeared in several conflicts, this idea that this is a form of extractivism in the almost mining sense. And another example, outside Catalonia, in this case Northern Africa, there's this mega project to have or create energy by Desert Tech company in the area of the Sahara. And we had an idea of exporting. And achieving European energy security. But the criticism that was not expected, but is to be expected, was of hard and pure extractivism.
En el mapa de
For
conflictividad de la
Professor Caroline Stamm, in the conflict map, it is not judged if the conflict is real or is legitimate. With the fact of having a demonstration only, would that be enough to provide legitimacy? I think that any conflict is legitimate if there is a group of persons mobilizing for that or against a decision uh, of their territory. But at least from social sciences, any type of mobilization is legitimate, at least to be considered. I don't know from the point of view of law. And then I don't know if to go to the Court of Justice, the debate is different there. But what we highlight of these mobilizations, that although there are I don't want this close to my house because it will devaluate the price of my home, of my house, or will have an impact that I don't want. It's not because you say, I mean, if they're not good arguments, but that doesn't mean that they're not legitimate. If there are arguments, we need to consider them. That is part of how we decide to live commonly, plan our territories, and decide on our territories. It is a two-sided answer. All of them, in my view, are legitimate, at least to be taken into consideration and to move towards a type of transformation or resolution, but at least to work on these conflicts. Thank you. And the last question for Professor Gonzalo Frei says, in what stage of development procedure of mediation or conciliation you would recommend a recourse or claim before the court? What would involve this? Well, the court receives issues once they have scaled, when communities have mobilized, or you want to stop an initiative that has already advanced. And the question is, how do we incorporate in our institutions mechanisms or strengthen? Chile does have citizen participation mechanisms. Probably there are deficits, but we need to ask what is happening in these early stages and maybe there strengthen mechanisms like facilitation or early citizen participation or mediation as prior to starting filing when there is already an opposition in a community to a certain initiative. It would save a lot of headaches. I mean, for those that instead of moving only when the building is already built or is at the 4th floor. So you need to strengthen these early stages of dialogue, of negotiation, of conversation. How do we understand our territory? How will investment be made in those territories? And with this, you need to strengthen this early stage. Also, it can be used later on, but you need to strengthen it at a stage of prevention or early working stages. Thank you very much. With this, we conclude the first panel, Alternative Resolution of Environmental Conflicts. And now to invite you to coffee and to continue later on with the second panel. Thank you very much. An applause then for our first panel moderator, Mr. Alamiro Alfaro. Now we'll have a 20-minute break for coffee, and we'll come back with a second panel on constitution and socio-environmental conflicts. You're all invited to networking and coffee break.